should time for oral argument be relaxed to allow the court to pose and attorneys to answer additional questions?
In my opinion?
Yes.
Absolutely. Absolutely. I would give to the Chief Justice discretionary power to increase answers, if you like, to increase time. I would like to see more time. I think there is, many cases we can handle in the half hour each side, but many we can't. I don't think we can. I think we'd be much better off with the discretionary power to have more time, but my colleagues, I don't have a majority there. They don't think that. There we are.
We've rarely had a court more dominated by former Court of Appeals judges and Ivy League law schools. Do we need more diversity, that is, Earl Warrens or others, who have a class
of a different set of experiences?
Yeah.
It helps to have people with, it does help to have people with different sets of experiences. I was a former appeals court judge, so I'm not going to underscore the wonderful characteristics of appeals court judges. You could have people with different experiences. That does add something. We don't know. The thing that we don't know, I was a law clerk during the Warren Court period. I worked for Arthur Goldberg. Now, that, I think, was a court with a mission. The court had decided Brown. They were trying to dismantle that apparatus of segregation was enormously complex in the law. And the court was not getting help from Congress. And it had decided this in Brown, that there will not be segregation. And then it had to follow through on that by going into all kinds of complicated ways. So I think there was a first and foremost overriding goal. And it might be that a person without the political experience of Earl Warren would have had less luck, if you like, or less ability to eventually help get this job done. I don't know. It's a different period now. Problems are different. Institutions are different. And so we don't know. In general, I think broader, different experiences is helpful. That's kind of hard to disagree with that one. But there we are.
Critics have raised a kerfuffle regarding the review, use, and possible reliance on foreign law in deciding cases in American courts. You have often turned to foreign law in your opinions. Could you speak about the reasons you think this is appropriate and how you respond to critics who say that an American judge cannot understand the cultural and legal context of other legal systems well enough to rely on foreign law, even if just for analogies?
I usually, when I say there are two questions. One is a really exciting, interesting question that isn't very important, and the other is a very boring question, which is very important. And the really exciting one is in the constitutional area, in the fairly small number of opinions where people have referred to foreign courts, and including me. They don't bind us. All right, they don't bind us, but what I usually say, here, I'll give you an example to show you how tough this is politically, not legally. We had a meeting where there was some kind of event. There was a member of Congress, and there was a judge, it was me, and there was some law professors or so forth. And the congressman then starts talking about just the foreign law is terrible, terrible, terrible. Goes on to use the American Constitution. So I said, well, he was a nice guy, actually, intelligent man. And I said, I guess that's aimed at me. So he said, yes, it is. So I said, look at it this way. It doesn't bind us. More and more countries throughout the world have constitutions like ours, democratic, and they want to protect fundamental liberties, and more try as an aid to doing so to have independent judicial institutions, courts, help do that. And problems are more and more the same. And their constitutions are somewhat similar. So if I find in a different country, someone points out that there is a person with a job like yours, who's had a case something like yours, who has institutions something like yours, who's interpreting a document something like yours, why don't I read it? I mean, it doesn't hurt. It doesn't bind me. But maybe I'll learn something. What's the problem? I thought that was a brilliant answer. So he says, go ahead, read it, just don't refer to it in your opinion. So I think, well, all right, I don't know when I should just keep quiet. So then I say, but it's something more than that. Many of these countries are just, in particular, they were Iron Curtain countries, for example. They're trying to establish new institutions, and the courts are pretty weak. And if they refer to our cases, we refer sometimes to their cases in the opinion. They can go to their legislature and say, see, we have some, gives them a little prestige, perhaps, or they can use it in a way that's helpful to keep them independent and not have I thought that was a really good answer. So he says, fine. He says, write them a letter. So I felt I wasn't winning this argument. But it's very hard for people to take this, many. I explain this to people. I have told you why I tend to do it. I think I might learn something. I might just disagree, but I might learn something. And sometimes I do. And there we are. I read all kinds of things. All sorts of things. Articles. I mean, it could be relevant. Why not? And I said, there was a woman who was really very intelligent. She said, but it's an American Constitution. I said, I know. Anyway, so the argument goes on there. And I don't think that's enormously critical for this reason. But the cases that have produced the political fallout, one of them was Lawrence, which involved gay rights. And one of them was Roper, which involved the death penalty for those under the age of 18 or whatever. So those are very politically charged cases. They have tremendous emotional reactions among many members of the public. So my wife, who is a psychologist, has taught me a word called displacement. And displacement is you're angry at A, so you blame B. All right, so I say they're angry at the results, so they're blaming foreign law, which really had nothing to do with those cases, but it's in there. So, but the important question, I think is terribly important, is that if you look at, as I did one year, I counted the number of cases that really involved foreign law. Now what? I mean, we had one year where there were 9 cases. 3 were Guantanamo, where we had all kinds of treaties. Put them to the side. There is a case involving an antitrust plaintiff from Ecuador who is suing a defendant in Holland and wants to sue in New York. Why? It involved a vitamin cartel. Well, why do you sue in New York? I said, I know it isn't because you were too weak having high-priced vitamins only. You couldn't get to Holland. It's because there's treble damages in New York. That's why. Well, can he or can he not? You have to know something about European law. And we were told in briefs filed by many countries, several countries, and the European Union filed a brief. Or there's a discovery case in Los Angeles where A wants information from B, 2 companies, that he says to give it to the cartel authority in Europe. The cartel authority says, we don't want it. All right, can the judge order it or not? Or the trucks coming in from Mexico under NAFTA, and Congress is trying to keep them out with a statute. Can they or can't they? Or Mrs. Altman, who wanted the Klimt painting, which she said that her uncle had rights to, and that the Nazis had taken it and given it to the Austrian Museum, and she's the residual legatee, and he died in Switzerland, and can she get this? Well, the museum asserted sovereign immunity, and now apparently there were a lot of buying and selling in their gift shop or something. They didn't have it, but they had it then, and should we look at were they sovereign then, or are they sovereign now, or was it then or now? And I think I thought I found the answer to that in a case from France, which is called Christian Dior versus ex-King Farouk. You see, he hadn't paid for his wife's clothes, and Dior sued him, and he asserted sovereign immunity, and the appeals court there in Paris said, wait, it's ex-King Farouk, get it? X, you're not king, no sovereign immunity. So I thought that was very helpful, in answering the question and there's the Warsaw Convention involving the liability airlines, and there are a lot of these cases. The world is going like this, as we know. There's commerce all over the world. And I say that's important because we don't know. I'm sure you understand that. I don't know the law of every country. I don't know, don't tell anyone I said this, the law of even one country, okay? But we learn in law school where to look. And the lawyers can find these cases and tell us, but they have to learn where to look. So it's chicken and egg. I mean, of course we have to look at foreign law for that, and the lawyers have to be able to point us to the right direction. And training in the law school is important in that respect, not in some special course called foreign law. It's usually called foreign law, the gut, all right? but it used to be. No, in a lot of courses where it's part of contracts, torts, or whatever. And I think that's very important, and I think that's the world we're going into. So,
I'm persuaded. You've served now on the Supreme Court for 17 years, 1 month, and 10 days.
Who's counting?
Who's counting? For the first 11 years you were on the court, you were the junior justice. There were no changes in personnel. In the past 6 years, 4 new justices have joined the court. Mm-hmm. How has the addition of new justices and the departure of old ones changed the court? It's been said that with the addition of each new justice, there's an entirely new court. And let me just add that this is the last question.
Well, Byron White said that. He was absolutely right. I was there 11 years. I almost held the record for being the junior justice the longest. I think I missed it by a couple of weeks. So I missed my chance to go down in history as the answer to a trivia question. But it does make a difference. It does. You have there are more women. Plus, there are different personalities, and the interaction is different. I'm probably somewhat more in dissent than I used to be. But even putting that to the side, it still is a human institution, and you have to take other people's views into account. You should, and so I have to say it's different. It's different. Well, how is it different? I can't tell you. I don't know. I feel the difference when you're there. It's fine. People get along well. I say I've now been there 17 years. I've never heard a voice raised in anger in the conference room. Never. That continues. And I've never heard one member of the court say something rude in that room personally about another one, not even as a joke. It's professional. We go ahead, make our points, we listen to other people, and there we are. And we decide. And that's continued. That atmosphere has continued. I think that's very helpful to getting our job done. So yes, there are changes. And no, I can't tell you exactly how, because it's hard for me to put it into words. Thank you. Thank you. Thank you. Thank you very much. Thank you very much. Thank you. Thank you. Thank you.
You know, within the next week, schools across the country will be celebrating Constitution Day. And what a delight for us to be able to have Justice Breyer kick off that week with such an interesting and variegated look upon issues such as separation of powers, intentionalism, textualism, and so forth. I also want to thank Carolyn Shapiro for putting this together, for launching iSCOTUS, and hope you get involved in its activities. Book signings are on the concourse, so please go there. The rest of you, join us for a reception on the first and second floors, but I want to tell you right now, there will be no chicken a la king. Thanks.